नहमदुहु व नुसल्ली व नुसल्लिम अला रसूलिहिल करीम फ़अऊज़ु बिल्लाहि मिनश शैतानिर रजीम बिस्मिल्लाहिर रहमानिर रहीम। लर्न लॉज़ यूट्यूब चैनल के मुअज़्ज़ज़ नाज़रीन, आज की इस नशिस्त में मैं आपकी खिदमत में एक बहुत ही इम्पॉर्टेंट टॉपिक पर डिस्कस करूँगा जो पर्टिकुलरली लॉ स्टूडेंट्स के लिए काफ़ी मुफीद साबित होगा। तो आज के इस वीडियो लेक्चर सीरीज़ के 4th एपिसोड में मैं रूल ऑफ स्ट्रिक्ट लायबिलिटी को कवर करूँगा। रूल ऑफ स्ट्रिक्ट लायबिलिटी was evolved by the English court in 1868. This was the mid of 19th century when industries and machines were growing. There was the period of industrialization. This was the era of machines. So in the process of development and the activities which were in the surrounding of human were causing risks to human body as well as human wealth. Till the period of 1857, the determination of liability was on the basis of fault, or the courts applied the fault theory for the determination of liability of the wrongdoers. But later, when a new situation was developed in Rayland versus Fletcher case, the court decided to evolve a new rule. When the case of Rayland versus Fletcher came before the Court of Exchequer, the sitting judge in the Court of Exchequer refused to entertain this case, where the Fletcher has suffered a loss of right, he suffered a loss of property due to the act of Rayland. So Fletcher came before the court and claimed for the recovery of his loss against Rayland. But on the side of Rayland, it was argued that this loss or damage was caused that I have no any fault in causing the harm of plaintiff. Till this period, the determination of liability was on the basis of fault, or the courts applied the fault theory for the determination of liability. So as per this theory, as per the fault theory, this situation cannot be dealt. So the Court of Exchequer refused to entertain the petition or claim of the victim. Victim moved to the appellate court, which was Court of Exchequer Chamber, presided by Justice Blackburn. The victim presented his matter before the Court of Exchequer Chamber, where Justice Blackburn was sitting. कोर्ट ऑफ एक्सचेकर चैम्बर के सामने फ्लेचर ने ये साबित किया कि आई हैव सफर्ड ए लॉस एंड हु इज रिस्पॉन्सिबल फॉर दिस लॉस इज द रिस्पोंडेंट हु इज रेलैंड. रेलैंड इससे इनकार नहीं कर सकता था कि ये जो लॉस फ्लेचर को हुआ है वो उसकी वजह से नहीं हुआ है. ये दीगर बात थी कि रेलैंड का यहाँ पर कोई फॉल्ट नहीं था. इस केस के फैक्ट्स कुछ इस तरह से थे कि रेलैंड ने अपनी इंडस्ट्री, अपनी फैक्ट्री में वाटर सप्लाई को मैनेज करने के लिए एक इंडिपेंडेंट कॉन्ट्रैक्टर से एक आर्टिफिशियल एक वाटर रिजर्वायर कंस्ट्रक्ट कराया. जिस इंडिपेंडेंट कॉन्ट्रैक्टर ने इस वाटर रिजर्वायर को कंस्ट्रक्ट किया था उसके इंजीनियर्स की नेग्लिजेंस की वजह से इस वाटर रिजर्वायर की जो वॉल्स थीं कहीं से कमज़ोर रह जाती हैं और जब इस वाटर रिजर्वायर में पानी स्टोर किया गया जो कि हैवी क्वांटिटी में था, पानी के प्रेशर से उन वॉल्स में जहाँ कमज़ोरी थी वहाँ से कुछ शेफ्ट्स ओपन होकर ये पानी फ्लेचर की माइन में एंटर कर जाता है जिसके सबब फ्लेचर को लॉस होता है. माइनिंग रुक जाती है, जो मिनरल्स उसके माइन में प्रेजेंट हैं उनकी क्वालिटी डिग्रेड होती है. अल्टीमेटली फ्लेचर सफर्ड अ लॉस और डैमेज. तो फॉर द रिकवरी ऑफ this damage, Fletcher moved the court. The Court of Exchequer refused to grant a remedy in the favor of Fletcher because of till this period the theory for the determination of liability was fault, or the determination of liability was only the fault. Or in this case there was no fault on the side of Rayland because he was careful in the construction of water reservoir. So he hired the services of a construction company and constructed this water reservoir through an independent contractor. और ये हम जानते हैं कि वाइकेरियस रूल भी इंडिपेंडेंट कॉन्ट्रैक्टर के केसेस में एप्लीकेबल नहीं होता है, जिससे कि हम इंडिपेंडेंट कॉन्ट्रैक्टर के रॉन्ग के लिए जिसके लिए कंस्ट्रक्शन किया गया है उसको वाइकेरियसली लायबल ठहरा सकें. तो rule of vicarious liability cannot be applied in this situation. But as we know that Fletcher suffered a loss, the Court of Exchequer refused to grant the remedy in the favor of Fletcher because there was no fault on the side of Rayland. Here the Fletcher moved to the higher court, that was the Court of Exchequer Chamber presided by Justice Blackburn. Justice Blackburn admitted this petition and evolved a new rule for the recovery of the loss. The observation of Justice Blackburn for the determination of liability of the Rayland, even without fault, was this: if a person who brings or accumulates things likely to cause damage over his land and the things escapes and cause harm to someone, then the person who brings or accumulates those things keeps at his own risk. If they cause harm to someone when escaped, the accumulator or who accumulates these goods or things shall be held liable for the damage suffered by someone. और इस तरह से जस्टिस ब्लैकबर्न ने एक नई सिचुएशन को डील करने के लिए एक रूल इवॉल्व किया और इस ऑब्जर्वेशन के मुताबिक, जस्टिस ब्लैकबर्न के इस ऑब्जर्वेशन के मुताबिक रेलैंड और फ्लेचर के केस के जो फैक्ट हैं, ये सिचुएशन डील हो जाती है उस ऑब्जर्वेशन से. So accordingly, the Rayland was held liable to compensate the victim. But now the Rayland was not satisfied with this judgment of the Court of Exchequer Chamber, and he moved to the appex court in England. Now the Rayland moved as an appellant to the House of Lords. Justice Cairns was there to hear this appeal. Justice Cairns was agree with the observation of Justice Blackburn, and he only added that there should be the non-natural use of land also for the determination of liability in such type of situations. According to this judgment of the High Court in Rayland versus Fletcher, if there is a non-natural use of land and the owner or possessor of the land keeps or brings or accumulate things likely to cause damage if they escape, the person brings or accumulate those things over his land at his own risk. So if there is a non-natural use of land, accumulation of things likely to cause damage, and if they escape and harms to another person, person who brings or accumulate those things likely to cause damage will be held liable to compensate the victim who suffer a loss of right, who suffer any kind of physical loss or loss of property. So according to the rule evolved by the House of Lords in case of Rayland versus Fletcher, ruled that if a person brings or accumulate things likely to cause damage over his land, and if those things escapes and cause harm to someone, if the use of this land is non-natural use of land also, the person who brings or accumulate those things shall be held liable for the recovery of the loss or to compensate the victim. लेकिन Justice Blackburn, who was presiding judge in Court of Exchequer Chamber, basically who evolved this rule of strict liability, also admitted that there are certain defenses which can be available in the favor of the defendant. These defenses may be act of God, act of third party, plaintiff's own default, statutory authority, etc. So, the rule of strict liability speaks that the liability will be held strictly. A person can be held even without his fault. So, this was the benchmark of this case, that till the date of 1868, when in Rayland versus Fletcher the rule of strict liability was evolved, before this period the determination of liability was on the basis of fault. If there was no fault on the side of the defendant, he or she cannot be held liable because of he was not at fault. But later, when in 1868 the rule of strict liability was evolved, this rule by the application of this rule, a wrongdoer or defendant can be held liable to compensate the victim even without his or her fault. This is the rule of strict liability. But later we have observed that there were so many industrial accidents where this rule of strict liability was also not capable to cover the situations or to deal the situations or to compensate the victims. For the today in our surrounding, number of threats to people, number of threats to property are existing. So in the situations which were developed in 20th century or 21st century, this rule of strict liability, indeed, which was an strict rule for the determination of liability, it was not capable to recover the loss of victim or to hold the liability of the enterprises. We have observed that there was a great human loss due to the accident happened in the Union Carbide Corporation in Bhopal, where in the midnight of 2nd and 3rd of December 1984, a great human loss in the human history we have visualized. Due to this accident, around 10,000 human lost their life. But this situation cannot be tackled by the rule of strict liability, because for the application of strict liability rule we have to ascertain three important elements which was mentioned in the observation of Justice Blackburn: accumulation of things, escape and non-natural use of land. साथ ही साथ along with this, certain defenses were recognized in the favor of defendant. So even the rule of strict liability could not applied to tackle this Bhopal gas disaster. Bhopal gas disaster, where we have seen a great human loss, the situation cannot be dealt with this rule of strict liability. So later on, there was a need of another advanced rule which can be applied for the determination of determination of liability of the defendant or to recover the loss of victims. So it was the period when the Supreme Court of India in 1987 in case of MC Mehta versus Union of India evolved a new rule for the determination of liability, that is known as a rule of absolute liability. So I will discuss in detail on this rule of absolute liability in coming lecture. Thank you for watching this